been arrested for DUI, it's only going to take a couple hours before one of your friends mentions to you, hey, you should get that reduced to reckless driving. Yes, here in Florida, you can have your DUI reduced to reckless driving. It's certainly an option. We call it a wet reckless. We also call it an alcohol-related reckless driving. And the penalties are pretty similar to a first-time DUI, but we all know that a reckless driving beats having a DUI conviction on your record. Now, this reduction can only come through negotiations with the prosecutor. You're not going to get this from the judge. And in most circumstances, a reckless driving is only available to a first-time DUI offender. So if you've got a prior DUI, you don't count on your second DUI being reduced to a reckless. Now, I've done it for clients. Other attorneys have too, but I just don't want you counting on it because it's so rare. Anyway, the question is, you probably want to know, how do we do this? How do we get these DUIs reduced to recklesses? Well, we got lots of ways, lots of tricks in our little bags. It comes down to plea negotiations. I want to review with you how we maneuver your case to get there. I would say the closer you blow to a .08, the better your chances are at a reckless. Also, we want to look at the stop of your car, because a questionable stop or a good stop makes all the difference. If you're accused of weaving or failing to use a blinker, that's a pretty questionable stop. If you were stopped for non-driving issues like a tag light out, I mean, come on. That the cop's just telling you, hey, you drove perfect, you didn't drive drunk, but something mechanically was wrong with your car. That's good for you. Also, we look at the field sobriety exercises. Again, all cops think you do horrible on the field sobriety exercises. We look at them again, and if you did well, we're going to get you a reckless driving. Also, the witnesses. We got to check the witnesses in the case, especially on an accident case. If they can't support the facts of the case, you might get a reckless. Aside from facts and all those issues, some counties, like Seminole County here in Central Florida, for example, they've set up ways to get a reckless driving without good facts. You can have bad facts. In Seminole, they call it the DUI First-Time Offender Program. And this program reduces your DUI to a reckless driving so long as you jump through a few hoops. Your attorney does need to negotiate you into the program, but it is a good program. And finally, I want to tell you that a reckless driving really is just a compromise and a negotiation with the state. Oftentimes, the prosecutors don't understand how weak their case is. So we defense attorneys will file a motion to suppress, motion to eliminate, motion to dismiss, just to remind them of what a crappy case they have. But the bottom line here is, I don't see this happening without an attorney. So please hire yourself a good local defense lawyer that handles DUIs. I do wish you luck on your case. Thanks for watching. Take care.